Hello, this is a school law review on Pregnancy Discrimination Act of 1978. My name is Takoa Thomas. This is for Dr. Don Hall, Educational Leadership 725, HR and Staff Development, August 4th, 2024. The context of the law. The Pregnancy Discrimination Act, also known as PDA, is a cornerstone that not only affects the educational sector, but many other sectors as well. And it has a significant impact on all of these areas. As a potential principal and an aspiring educational leadership, understanding the implications of this law is crucial for understanding the inclusive and the equitable environment for all staff members. This PowerPoint will talk about the societal context during the passage of the PDA, its components, two recent court cases, and the relevance to education as well as educational leadership. Hopefully, this PowerPoint will provide a comprehensive understanding of PDA and its importance in the educational landscape. Context of the law continued. The Pregnancy Discrimination Act was passed in 1978 as an amendment to the Title VII of the Civil Rights Act of 1964. And if we can remember back during the Civil Rights era, the Civil Rights Act of 1964 basically guaranteed rights and privileges and freedoms to not only African American people, but just people of minorities altogether, which include people who are disabled, people who have medical issues, people who are women who are pregnant, even gender issues, racial issues, as well as disabilities. So this particular amendment worked for women who were pregnant, who were denied access to upper level jobs due to them being pregnant, as well as being a woman. One of the driving forces behind the passage of the PDA was the need to protect pregnant women from workplace discriminations. Before the onset of the Pregnancy Discrimination Act, it was common for employers to fire or demote women upon learning of their pregnancy. Some of these women were denied employment opportunities altogether. The PDA was enacted to ensure that pregnant women receive the same treatment as other employees with similar abilities or limitations. And as you can see within the picture, this picture is a basic description of women of different areas, just not European, but different minority styles of women. Some older, some younger, some in construction, some in healthcare fields. Looks like one of the lady on the end, she may be a cook. And I'm not sure about the lady with the bond on her head, but she's pregnant as well. So this act was instituted to protect all women in all areas of employment. All right, let's look at the content of the law. The Pregnancy Discrimination Act explicitly prohibits the discrimination based on pregnancy, childbirth, or related medical conditions. It mandates that pregnant women must be treated the same as other employees who are similar in their ability or inabilities to work. This means that employers cannot refuse to hire a pregnant woman, fire a pregnant woman, or deny her a promotion simply because of her pregnancy. Additionally, the PDA requires employers to provide reasonable accommodations for pregnant employees, such as modified tasks or alternative assignments. If they do so for the other employees with temporary disabilities, they must do the same thing for women who are pregnant. The PDA is considered a cornerstone law because it addresses a fundamental issue of gender equality in the workplace and has set a precedent for other anti-discrimination legislation. So a quick example of this would be if a woman, let's just say a lady was working in construction, and upon her working, and she finds out that she's pregnant, and she also lets her boss know the boss cannot fire her due to her being pregnant. He must make accommodations for her at the moment while she's pregnant. And also she is offered the time off from work. She can't be punished or penalized due to her being pregnant. And if there's a violation that occurs, then I'm quite sure that there are legal ramifications that will take place due to her rights being violated. All right, let's move on to the next slide. Recent court cases that we can discuss real quick. One of the cases has a good ending, and the other case has a ending that is, I guess, beneficial to the company. So let's talk about the case real quick that deals with the benefit of the young lady. All right, the Supreme Court case of Young versus the United Parcel Service, which is UPS, of 2015. This case was actually, well, I think this case actually occurred in 2007, but to talk about it, it addressed significant issues pertaining to employment discrimination and the rights of pregnant workers under the Pregnancy Discrimination Act. The lady's name was Peggy Young. She was a part-time driver for UPS. She became pregnant in 2006 and was advised by her doctor not to lift more than 20 pounds. UPS, however, required drivers to lift parcels weighing up to 70 pounds and denied Ms. Young the accommodations that she sought, leading to her. This led to her to take an unpaid leave of absence. So this lady made the decision to take off from work or to just simply stop going and request a leave of absence and she not be paid. She wasn't terminated, but she felt as if her rights were violated. And the courts agreed with her. This landmark case had profound implications for employment law, enhancing protections for women workers, pregnant workers, and clarifying how courts should interpret the PDA when assessing potential discrimination. The decision underscores the importance of equitable treatment, meaning fair treatment in the workplace, and reinforces the principle that pregnant employees are entitled to the same accommodations as workers who are similar in their abilities or inabilities to work. So basically, this compares her with someone who's not pregnant, and how they should make accommodations for her being pregnant. And if she had a doctor's excuse, if it wasn't in violation to the policy at the workplace, the United Parcel Service, which we see that it was, with her having to lift 70 pounds when the doctor's requiring her to only lift 20 pounds, this would mean that her rights had been violated against the PDA Act. All right, that means that they have to accommodate her. All right, the next case that I want to talk about, I really can't pronounce her last name, so I'm just going to call her Miss Sophia. She was a certified nursing assistant who worked at a nursing home facility. She had a lumbar degenerative disc disease, and if I'm understanding what the word degenerative means, meaning that it's ongoing and it's going to continue to happen for her. So, Mrs. Sophia, she worked with the Beverly Nursing Home facility. She was terminated after exhausting all of her unpaid leave, and she was unable to return to work. She sued the Beverly Nursing Home facility, alleging that she was discriminated against based on her disability. The conclusion was that Mrs. Sophia did not provide sufficient evidence that she was disabled under the ADA's definition. The court found that the accommodations that she requested were not reasonable and that Beverly Healthcare had acted within its legal right. All right. Now, when I talk about, let's go back to the degenerative disease. I'm sorry, I'm getting tongue-tied. If this was going to be an ongoing thing, meaning that it was going to continue to break down and cause her issues, then she would have to make some changes and some decisions, knowing that she wouldn't be able to return to work because of the breaking down of her lumbar area. So with her not being able to return to work, she possibly abandoned her roles at the nursing facility. And it's understandable, but it's a catch-22. I hate that this happened to her. But when you're in these particular areas of work, if it's not documented and she like they say that she couldn't prove her disability, then you wouldn't have a case. So this is a case that shows how the law is evaluating and coming up with their I guess their definitions of what is actually discrimination according to the Civil Rights Act. The court found favor in the Beverly nursing home, ruling that Ms. Sophia was not a qualified individual because she could not perform the essential functions on her job due to her medical condition. So that means that she had to be let go because she was not qualified. Furthermore, the court held that her request for indefinite leave was not a reasonable accommodation under the ADA. This decision underscores the importance of definitions of qualified individual and reasonable accommodation within the framework of ADA litigation. So definitions and understanding are very important parts of understanding the breakdown of the law, what you qualify for and what you don't qualify for. All right, the application to education and educational leadership. The Pregnancy Discrimination Act has had significant implications for education and educational leadership. Schools, as employers, must ensure that pregnant employees, including teachers and staff, are not subjected to discrimination. This includes providing reasonable accommodations and ensuring that pregnant employees have equal opportunities for promotions and professional development. Educational leaders must be aware of the PDA and its requirements to create an inclusive and supportive work environment for all employees. Understanding the PDA can help educational leaders advocate for policies and practices that promote gender equality and support the well-being of their pregnant employees. Legislation needed for the Pregnancy Discrimination Act. All right. Things that I feel like they need to do to make the act better. They need to include a more comprehensive paid parental leave so that new mothers can focus on motherhood rather than finances during the first few months of the new baby. You have women who are fighting for, I guess, the time off from work as well as being compensated for being off work during that particular time. I have not had the pleasure of having to know anyone who's not compensated within my school district during their pregnancy, but I'm quite sure that there are other agencies where women are I'm not going to say forced to take off work, but the maternity leave is not acknowledged. So they have to work up until the time that they basically deliver the baby. And sometimes they have complications and they're having to worry about finances. So I would say that we needed a more comprehensive plan for women who are pregnant to be able to enjoy motherhood rather than just focusing on the finances. So that would be one thing. Another thing that I would say would be to update the coverage criteria to include small businesses as well as part-time employees. So part-time employees who work for agencies and schools and other organizations, they don't have the luxury of having the paid time off to actually consider being off work to have a baby. To be able to support that baby, they have to work up until the time. So I would say that needs to, coverage should be included for those workers as well as providing the opportunity for small business owners to have the time off from work and to be able to have the finances to support their children as well as themselves and still be effective when they come back for the businesses and the companies and the schools. One more thing that I would do that would hopefully benefit, what I would request legislation for the Pregnancy Discrimination Act would be to enforce stricter penalties for violations of the Pregnancy Discrimination Act. Hopefully, if they would enforce stricter penalties, you would have business owners and employers not putting women who are pregnant in these situations to have to make decisions to either leave their job or to take unpaid time off. This discrimination would deter employers from discriminatory practices and provide a clear pathway for justice and recovery for women who have been violated against. Reason why I chose this law review deals with women's rights. As a woman, the fight for gender equality and workers' rights in the United States has been ongoing. Women were most times discriminated against in the workplace prior to the civil rights era of 1964. The PDA explicitly prohibits discrimination on the basis of pregnancy, childbirth, or related medical conditions, thereby mandating that pregnant employees be treated the same as others with similar work abilities or limitations. This law remains incredibly relevant as it is continuously serving as a benchmark for fighting against such discrimination and advocating for fair treatment in the workplace. So since 1964, since before 1964, women have been faced with gender inequality in various aspects. And I have the pictures here to kind of give us, I guess, a roundabout era of what it looks like. The first picture deals with a woman standing in front of a hand that's stopping her with the child while she's pregnant. And it shows that there's like a office set up next door behind the hand. So that's showing that a woman who is pregnant or a woman who has children cannot work in this particular area of employment in this particular cartoon. The next picture shows a myriad of different people, variety of people. We have a Caucasian man, we have a woman who is dressed in Indian or Muslim attire, we have an African American man, we have another African American man with blonde hair and a black beard. We have an older lady, and we also have someone who is disabled. So this picture shows how discrimination looks and what we should avoid. The last picture shows the gender inequality in the workplace as far as we dealing with salaries and pay scales. As we can see in this particular picture, the lady is on a downward decline and the man is on an upward incline as he's sitting on a dollar bill. So that lets you know that women are still affected to this day by gender discrimination. So it was important for me to look into this and to see some of the cases that have transpired. And I'm still just taken aback as to why we are still fighting for these rights in 2024. You have women who are adequate in the workplace just as well as men, but they have a very hard time. And the Civil Rights Act of 1964 is what has been established to try to safeguard workers' rights for all. This is the end of my presentation. I want to thank you, and I hope I've given some insight into the school law review on the Pregnancy Discrimination Act of 1978. And my last page shows my references, talks about the Civil Rights Act. My next references was the enforcement on the Pregnancy Discrimination Act. The next to the last one was about the Beverly Healthcare case that dealt with Miss Sophia. And my last reference dealt with the Supreme case of Mrs. Young versus the UPS service. So thank you, and I hope that it was very informative.